I did already explain earlier, and I essentially stopped discussion and testimony on whether there's an irreparable harm. Certainly, Edgewood High School, the students, the whole community, the students on the team, if they should be allowed to play in the tournament and aren't allowed to, that would be an irreparable harm. There's no way to get that back. There's no way to get that experience back. You don't get to come back and redo things like that. I accept that that factor, that there is irreparable harm, exists. You would only suffer an irreparable harm if you're entitled to and don't receive a temporary injunction. I don't agree that's the case here, and I'll get into why later. For the no other adequate remedy at law, I'll accept that as proven here as well, that this is the only forum left to contest this issue and try to get some relief. Then there's the fourth factor, which is that a temporary injunction is necessary to preserve the status quo. I don't agree that's been satisfied here. The status quo is that the WIAA found that Edgewood had an ineligible player during the season and during one of the two playoff games that have been played so far, and therefore disqualified Edgewood from the remainder of the tournament. And it also had consequences relating to forfeiting games that occurred during the season with that player. What's being asked here is that I undo that status quo, that I issue a temporary injunction to take us back in time to the status quo before the WIAA acted. So I don't find that that standard has been met here, though I suppose it could be, and I would return to this status quo if I agreed that Edgewood was likely to succeed on the merits of its request, but I'm finding that I don't believe they are likely to succeed. Now, this is preliminary, and I may be proven otherwise as the litigation progresses, but based on the testimony heard today, I simply can't find a likelihood that plaintiffs are going to succeed. I'll go through each of the claims and explain why. Claims 1 and 2 were essentially asking for a declaratory judgment that in fact that Edgewood had not violated the rule, and as well as that Mr. Fain was in fact an eligible player, that he was never an ineligible player, that he was entitled to play all year and during the tournament. But the facts prove he was ineligible under the WIAA rules. As of this fall, he's in his 9th semester. The WIAA says after 8, you're ineligible to keep playing unless you get an exemption. And the testimony was undisputed once we heard from Mr. Zwettler that Edgewood knew when they were submitting that application in the spring of 2021, which was Mr. Fain's 8th semester, that he had completed 7 already, that he was going into his 8th semester. They knew that. And Mr. Zwettler also said he knew that you're ineligible after 8 semesters. He explained that in his mind, because Edgewood was letting Mr. Fain enroll as a 6th semester junior, that therefore that means he, I guess, wasn't in fact going into his, at that time, 8th semester and then going to have a 9th and 10th. If I would declare that acceptable, and that if a school just decided to put someone in a semester that didn't match reality, that was the end all be all, then this rule would essentially have no meaning. If schools could unilaterally decide to move somebody's semester from what it actually is to something else and thereby avoid the WIAA rules, it would make the rules meaningless as far as the 8 semester limitation. That would be negative for every member of the WIAA. I imagine if I declared that at the next annual meeting, there would be a rule entered that did not allow that to happen. But I just don't believe the rules allow that anyway. You don't get to ignore semesters, and the undisputed facts are that he's in his 9th semester. Therefore, the rule applies and says he was ineligible after 8, unless he's exempted. And he wasn't exempted. The arguments that somehow the letter from the WIAA saying that he was cleared of the prohibitions for playing for a calendar year in varsity sports based on transferring, it was limited to those restrictions relating to a transfer and the penalties that imposes. I don't know if penalties is the right word, but the disqualification that provides. Those are different rules than the rules regarding having 8 seasons of eligibility. And it seemed pretty clear that Edgewood knew their different rules. Mr. Zwettler very clearly testified, and I believe him, that all he asked for was to have those transfer restrictions lifted. That's all he thought he had to ask for, so that's all he did ask for. He can't possibly have asked for something beyond what he meant to or thought to. And that matches with the testimony from the WIAA that, in fact, when they granted that waiver or that exemption, all they meant it to apply to was the transfer, because that's all that was asked for. If, in fact, Edgewood was actually asking or hoping that it would apply to the 8 semester limitation, well, then Edgewood has some problems, because they were not forthcoming with the actuality of Mr. Fain's school records and how many semesters he had spent in school. In at least 3 different documents that we looked at today, Edgewood represented or allowed other people to represent that Mr. Fain was a junior, when in fact he was a senior, and that they were reclassifying him as a junior. That included saying that he was in his 6th semester, when in fact he was in his 8th semester. That included calling him a junior and saying he was transferring as a junior. That was true on one end, I suppose, that Edgewood was treating him as a junior, but it was false in that the school transferring him out treated him as a senior. And then there was another document where it was marked that he was a junior. Not a single document ever mentioned that he was in his 8th semester or that he had completed 7 semesters prior to that. If you really wanted to ask for a waiver of the 8th semester limitation, you would have to actually talk about the fact that this person had completed or was completing 8 semesters and was going to be back in high school for a 9th or 10th or a 9th and 10th semester. Edgewood never did that. They never pointed it out. Mr. Zwettler agreed he never pointed it out, because it never occurred to him to point it out, to ask for that. So there is not a reasonable likelihood of success on claims 1 or 2.